Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Certificate in Patent Practice, Pgcpp. MIR 022 International Framework for Patent Protection. Block 1 Wipo Administered Treaties. Unit 4 Wipo-Ii, Development, Enforcement of IPR and Resolution of Disputes. 4.1 Introduction. In the previous unit you learnt about how Wipo evolved to meet a basic need to safeguard intellectual property and encourage creative activity in diverse fields that add to generation of wealth of nations. You also learnt about the objectives of Wipo, as also its organizational and administrative structure and the significant role it has been playing as an organization of the UN. In the present unit we will learn in some detail about the role of the Wipo in three important areas, namely cooperation for development, enforcement of IPR, resolution of disputes. 4.2 Objectives. After studying this unit, you should be able to understand the dimensions of the Wipo's development cooperation programs in the field of intellectual property for developing countries in transition to a market economy and least developed countries, LDCs. Explain the function of the Wipo Worldwide Academy. List the activities undertaken by Wipo concerning enforcement of IPR and describe the role Wipo plays in the resolution of disputes concerning IP. 4.3 Cooperation for Development. Wipo's development cooperation aims to assist developing countries, including the least developed countries, LDCs, for which a special unit has been established in the Wipo Secretariat, and countries in transition to attain levels of socio-economic development through their intellectual property systems, which enable them to enter into effective partnership with more developed countries, and generally to take their place in the world. The objectives of Wipo's development cooperation programs are achieved either directly, by providing legal, practical and administrative information, advice and training to governments and organizations in developing countries, or indirectly, by facilitating their contacts with public and private bodies worldwide, which can also thus assist them. The major objectives of the development cooperation programs are to assist the said countries in, the establishment of intellectual property systems which are modern and function well, with regard to legislation and administration, and with personnel adequately trained and using up-to-date equipment. The development of human resources, especially by the Wipo Worldwide Academy. The adoption of timely and informed policies to meet existing and new intellectual property challenges such as the preservation, conservation and dissemination of biological diversity, the use of traditional knowledge to benefit the holders of it, the improved protection of expressions of folklore, and the implications of electronic commerce. The promotion of cooperation among developing countries, in particular by the use of the Wipo Global Information Network, WIPONET, in order to pool all available useful technological information resources at sub-regional and regional levels. The creation and use of intellectual property through the setting up of innovation support structures and technology transfer. The development and adjustment of information technology, in both its legal and practical aspects, to harmonize and enhance its intellectual property application worldwide. In order to carry out activities to fulfill these aims, Wipo undertakes projects and activities tailored to the needs of particular groups of developing countries. 52. A single permanent committee on cooperation for development related to intellectual property was established in 1999 to direct permanent programs in the fields of both industrial property and copyright and related rights. Its membership is open to any member state of Wipo. The Permanent Committee is a forum for debating policy and practice in intellectual property matters of particular concern to developing countries. Its sessions have especially reviewed WIPO's newer initiatives to help developing countries to meet those challenges. The major subjects of discussion have been, among other things, the development of human resources in the context of the work of Wipo's Worldwide Academy, assistance to the least developed countries, LDCs, the promotion and development of collective management of copyright and related rights, notably in connection with the development of a regional system, the promotion of innovation in all fields of intellectual property to stimulate economic growth and culture. New approaches to traditional knowledge, genetic resources and folklore, and, in support of all these and other activities, measures required to enable developing countries to benefit fully from the latest information technology. The Permanent Committee will continue to meet biennially. Development cooperation activities. WIPO's development cooperation activities in the field of intellectual property are aimed at helping developing countries in the following respects: training of government officials and representatives of the private sector, such as lawyers, agents and staff of collective management organizations working in the fields of copyright and related rights, providing legal advice and assistance in drafting new or revising existing intellectual property legislation, establishing or strengthening intellectual property offices and other related institutions, promoting indigenous innovative, inventive and creative activities, using the technological information contained in patent documents, establishing programs for legislators and the judiciary, promoting awareness of intellectual property protection in local enterprises and educational institutions, training. WIPO's training program consists of various regular general and specialized courses, organized each year in a number of developed and developing countries for the collective training of government officials and others, and periodic seminars, workshops and other types of meetings at the national, sub-regional and regional levels in which government officials and other personnel from developing countries participate. In addition, government officials are attached to intellectual property offices and other institutions in developed or developing countries for practical training and middle and senior level. Officials are sent on observation visits to such offices. WIPO also organizes on-the-job training in some countries by international experts. The level of training ranges from basic, introductory courses to refresher or specialization courses for officials in responsible positions in intellectual property administrations. Training programs have been extended to other categories of beneficiaries, in addition to the government officials working in the national intellectual property administrations. These categories include private lawyers and practitioners, staff of research and development institutions, of enterprises and of collective management organizations, representatives of the judiciary, officials of enforcement agencies such as police and customs, of ministries of trade and foreign affairs and other persons dealing with questions related to intellectual property matters. It is also desirable that the teaching of intellectual property law should be developed in a number of universities in developing countries. The International Bureau has already awarded fellowships for this purpose to university teachers from developing countries, to enable such personnel to examine the course and curriculum content in order to introduce or strengthen teaching at the university level. This means a more intensive involvement in the training of trainers. The aim of the training activities is to enable government officials and other personnel from developing countries and countries in transition to acquire knowledge and practice in the various aspects of intellectual property, so that they may effectively organize and administer the intellectual property system of their own countries. Training activities occupy a preeminent place within WIPO's development cooperation program because laws and institutions, however good they may be, are of little use without qualified staff to administer them. Legal advice and assistance. In recent years, there have been many instances of a growing interest, on the part of governments of developing countries and transition countries, in making intellectual property an effective tool in the development process. The existence of intellectual property laws suited to the needs of the country concerned is a precondition of an effective intellectual property system. For this reason, WIPO has received many requests for advice in drafting intellectual property laws where they do not exist, and in revising existing laws which are inadequate for the country's economic needs and priorities. In addition, adherence to international treaties oblige countries to adapt their legislation in order to meet the protection requirements established in those treaties. At the request of a government, WIPO comments on draft legislation prepared by the government or prepares draft legislation with due regard to the wishes of the government and the needs of the country concerned. These wishes and needs would have been ascertained through consultations and surveys made on the spot by Wipo experts. The draft texts are then submitted to the authorities for study and comment. What follows is often an exchange of letters and visits between the authorities and Wipo experts to clarify and improve the texts. Legal assistance is provided by the International Bureau of Wipo in two forms: the drafting of model laws and assistance in the drafting of national legislation. The International Bureau has already drawn up a number of model laws for the use of the developing countries. These texts are prepared by meetings of experts from developing countries and developed countries, working on the basis of drafts prepared by the International Bureau and, in all cases, submitted for their comments to the states and subsequently adopted by meetings of governmental experts. In addition, Wipo has produced model laws or guides for developing countries dealing with such subjects as patents, trademarks, industrial designs and industrial property, licensing, copyright and related rights, the implementation of treaties, the implementation of licensing procedures for translation and reproduction licensing under the Berne Convention, and the protection of traditional knowledge and expressions of folklore. Institutional assistance, A law is not an end in itself for the country concerned. It provides an important framework within which its industrial property system will function. The law must be administered and used, and for that purpose suitable administrative machinery and procedures are required. Here again, Wipo has considerable expertise to offer to governments and institutions. Wipo experts are sent, on the request of countries, in order to give on-the-spot advice on such matters as the establishment, streamlining and automation of procedures, preparation of organograms, acquisition of appropriate equipment including computer hardware and software, acquisition of the required technical documentation, establishment of links with external institutions, assessment of staff requirements and training needs, utilization of office space, and the determination of suitable fee schedules. In the copyright and related rights fields, Wipo has paid special attention to the establishment and reinforcement of collective management systems, which undertake the safeguarding of the rights and interests of authors, composers and performers, and the collection and distribution of their royalties, and which also contribute to the promotion of education and culture, as well as assisting in participation in international cultural exchange. Often, such administrative improvements and changes are planned for implementation over a period of time by Wipo in consultation with the authorities concerned, depending on priorities and available resources. For an intellectual property administration system to be useful, it must serve the public. In many countries, the intellectual property system has not been used to full advantage. Partly because the public, including creators and business circles, are unaware of the advantages the system has to offer, and its role in the development process. Wipo-Ii therefore organizes meetings which aim at building, to start with, awareness of intellectual property by answering such basic questions as what is intellectual property, what are its constituent elements, how does intellectual property help trade, technological development and cultural development, and how to use and protect intellectual property rights at the national level, promotion of indigenous creativity, innovation, and inventiveness. As observed earlier, the role that the intellectual property system can play in technological, economic, and cultural development has long been recognized in developing countries. The protection afforded by intellectual property laws results in more creations, innovations, and inventions, more investment and effort in research and development, R&D, in technical fields, leading to technological improvements, and thereby to improvement in the quality of industrial output, and by greater access to creations of foreign origin, in an educational and cultural climate which promotes development in general. Without a national intellectual property system, it is difficult for a country to stimulate and protect the results of indigenous creativity and innovation. Governments can, with the help of Wipo experts, devise ways and means of encouraging local entrepreneurs and enterprises, the creation of national associations in the field, the provision of legal advice on protection procedures, financial support and incentives, public recognition of creators and inventors, the award of prizes through competitions, etc. through mass participation in nationwide events and competitions, and in clubs in schools, public consciousness and use of the intellectual property system is stimulated. One example is that since 1979, WIPO has established an award for inventors and innovators that is widely used by developing countries to encourage inventive activity. Use of patent information. One of the activities of WIPO in assisting the development process in developing countries is directed at improving access by those countries to the technological information contained in patent documents, by the provision of the necessary patent documentation and training in methods of retrieval and dissemination. A program, now called the WIPO Patent Information Services for Developing Countries, began in 1975. Its aim is to provide free of charge patent information services to institutions in developing countries under agreements concluded between the International Bureau of WIPO and contributing industrial property officers in industrialized countries. WIPO gives assistance and advice, and is the executing agency for several UNDP projects concerning the planning and establishment of patent information and documentation centers which serve the needs of national or regional institutions in developing countries. Such centers may be created within an existing or planned industrial property office, or within a scientific and technological information center. Programs for legislators and the judiciary. WIPO cooperates in promoting the exchange of experience and other information among legislators so that they are better prepared to consider the needs and find solutions to such needs of their own countries when engaged in the adaptation of their intellectual property legislations to the changing economic and technological situation, both on the domestic level and in international relations. This cooperation may take the form of national and regional seminars and study trips. In addition, WIPO works to promote the exchange of experience and information among members of the judicial branch, judges of courts of all levels, so that they are better prepared to interpret and apply domestic laws and international treaties in the field of intellectual property law and to order measures that would prevent the continuation of infringement of intellectual property rights. Such cooperation may also take the form of national and regional seminars, simulated trials and study trips. Promotion of awareness in local enterprises and educational institutions. It is increasingly recognized that efficient use of the intellectual property protection system can significantly contribute to economic growth. In 2000, WIPO developed a new program of substantial new activities focusing on the needs of small and medium-sized enterprises, SMEs, worldwide in the field of intellectual property. A new SME division has been established in the WIPO Secretariat, with the aim of encouraging SMEs to effectively utilize the intellectual property system. These activities recognize the important role played by such enterprises in strengthening the economic well-being of a country. Research has shown that SMEs can and should contribute considerably to employment creation and trade, which ultimately promote economic growth. It has also been shown that, given the opportunity, SMEs are innovative and competitive. However, SMEs need to be encouraged to take full advantage of the existing intellectual property protection system in order to compete more successfully in the global economy. One of the priorities under the new program will be to raise awareness of the potential benefits for SMEs so that they will effectively use that system. The awareness building activities will be for government institutions responsible for SMEs, other institutions supporting SMEs and, through information made available on the internet, for SMEs themselves. These will include international, regional and national seminars organized by WIPO, distance learning courses offered by the WIPO Worldwide Academy, and joint activities in cooperation with other international or regional organizations or institutions which deal with matters concerning SMEs. WIPO has already been active in raising awareness of the value of the intellectual property system in higher education through cooperation activities with universities and similar institutions to include intellectual property in teaching programs. A number of cooperation agreements have been concluded with universities and regional training centers towards this aim. See under the WIPO Academy. The WIPO Worldwide Academy. The WIPO Worldwide Academy was established in March 1998. It is WIPO's central coordinating institution for human resources development. The overall objective of the Academy is to serve as an educational institution providing teaching, training, and research services in intellectual property, particularly for developing countries and countries in transition. In order to meet its objectives, the Academy carries out its programs both at WIPO headquarters in Geneva and in different parts of the world, and cooperates with several academic institutions and intellectual property offices. Owing to the rising level of activities related to intellectual property in member countries, the demand for tailor-made programs has continued to increase steadily. In response, the Academy expanded the scope of its training programs in 2000 to include courses and seminars on the legislative, administrative and enforcement aspects of intellectual property systems. The programs of the Academy comprise three main categories, namely, professional training, policy training, and distance learning. The professional training program offers intermediate and advanced training courses for managers and technical staff of intellectual property offices and other professional users of the system. These courses are not only for persons working in intellectual property offices, but also for those involved with research work in universities in research and development, information and exchanging views on the experience of other countries in using the intellectual property system as a tool for development. In addition, special academy sessions are organized for specific interest groups and also deal with special or topical issues, such as strengthening the teaching of intellectual property for professors and the enforcement of intellectual property rights for the judiciary. The distance learning program is an advance in teaching methodology, with the attendant advantages of flexibility of time and space, cost effectiveness, and the capacity to reach the unreached. Distance learning courses are a complement to traditional training methods, as well as a means of increasing the range of training beneficiaries. These courses are delivered via the internet, using a format that allows for online registration, student-teacher interaction, student tests, course monitoring and evaluation systems. In addition to a general course on intellectual property, 5 specialized advanced distance learning courses which focus on specific aspects of intellectual property are to be launched. The Academy also organizes diploma programs on intellectual property law in cooperation with universities and other institutions, such as an intellectual property law program with the University of South Africa, a master course on intellectual property with the University of Turin, Italy, and the qualification of Master of Intellectual Property Law and Human Rights with the Raoul Wallenberg Institute of Human Rights and Humanitarian Law, University of Lund, Sweden, and the Post-Graduate Diploma in Intellectual Property Rights with the Indira Gandhi National Open University, IGNOU, New Delhi, India. 4.4 Enforcement OFIPR. The repression of activities such as piracy and counterfeiting, which are factors of major economic importance, is a crucial task of WIPO. It comprises 3 main fields of activity. Firstly, WIPO administers many international conventions and treaties relating to intellectual property. This aspect of WIPO's work consists basically of ensuring the proper operation of the bodies that govern these various international agreements and to obtain the accession of the largest possible number of states to them. For any repression to have proper effect, it is, indeed, necessary that the most uniform legal framework possible be established, comprising high-level provisions well adapted to new circumstances and the new technological facilities available to pirates. A second aspect of WIPO's task is to develop new legislative provisions, both to adapt existing provisions to the new technologies and to reflect the progressively emerging consensus in favor of increasing the level of these provisions. For example, the impact of digital technology on copyright and related rights is enormous. The ability to transmit by electromagnetic waves, by cable or by satellite, musical works that are incorporated in sound or audiovisual recordings increases the problem of unlawful reproduction and also of private copying, since works stored in digital form can be reproduced any number of times without loss of quality when compared with the original from which the copies are made. Another basic aspect of Wipo's activities, but an essential one, is the transfer of know-how required to administer the international conventions. Indeed, it is of prime importance that the provisions drawn up at the international level be applied at the national level, since promotion of creativeness first requires suitable management and the implementation of provisions adopted in favor of creators. Wipo's development cooperation activities are particularly important in this respect. From the late 1990s until 2001, there were initially two Wipo committees on enforcement: the Advisory Committee on Enforcement of Industrial Property Rights, and the Advisory Committee on the Management Non-Enforcement of Copyright and Related Rights in Global Information Networks. The Advisory Committee on Enforcement of Industrial Property Rights held a meeting in October 2001, in which member states asked the Secretariat of Wipo to initiate studies and activities to promote more effective enforcement of industrial property rights worldwide, and the identification of good practices and procedures with which to do so, while keeping the time and cost burden on administrative infrastructures to a minimum. In September 2002, it was decided that these two committees would be merged into a single advisory committee on enforcement, responsible for all intellectual property enforcement issues. Full membership is open to member states of Wipo and/or the Paris and Bern unions. It met for the first time in June 2003. 4.5 Resolution of Disputes. Wipo Arbitration and Mediation Center. In September 1993, the Wipo General Assembly unanimously approved the establishment of the Wipo Arbitration Center, now called the Wipo Arbitration and Mediation Center. The center offers services for the resolution of intellectual property disputes between private parties through arbitration and mediation. The center also administers special administrative procedures for the resolution of disputes arising out of the registration of Internet domain names. See section below. The center was created to bridge two areas which have recently undergone considerable changes in parallel to, rather than in conjunction with, each other. These areas are arbitration, or more generally, arbitration and dispute resolution, ADR, on the one hand, and intellectual property, on the other hand. The number of institutions administering arbitration throughout the world has grown considerably, as have the numbers of arbitration proceedings initiated. At the same time, particularly in the United States of America, the types of ADR procedures available have evolved beyond traditional arbitration and mediation to include new forms adapted from the classical model of arbitration, mini trials, and various combinations of procedures. The increasingly technological basis of production, the emphasis on image and marketing for the distribution of goods and services, and the proliferation and variety of media of communication have all contributed to giving unprecedented prominence to intellectual property. The increase in the number of intellectual property titles sought is mostly due to the increase in foreign origin applications. This reflects the internationalization of markets. As enterprises seek to penetrate a wider geographical area, they seek wider protection for their intellectual property. The increased resort to international protection of intellectual property opens new possibilities for the use of ADR. The existence of more rights raises the potential for a larger number of conflicts involving those rights. Often, however, those negotiating the licenses and other contractual arrangements pay more attention to the successful conclusion of a potential business arrangement than to the consequences of any breakdown thereof. The developments in the area of arbitration have not necessarily found expression in contractual provisions directed at the efficient resolution of possible disputes. In addition, the existence of a multiplicity of national and regional rights covering the same subject matter indicates the need for dispute resolution procedures which avoid recourse to different national court actions. Even if a multiplicity of separate national claims is not involved, the opposition of two foreign parties necessitates dispute resolution procedures that avoid the court system of one of the parties. Besides the recent evolution of intellectual property protection, many of the traditional advantages in favor of ADR apply particularly to intellectual property. The frequently multi-jurisdictional character of intellectual property disputes, and the opportunity to resolve such disputes in a single forum, have been mentioned above. Furthermore, the possibility to choose neutrals with specialized expertise is of great importance in the highly technical and scientific subject matter covered by patents, trade secrets, copyright, and plant variety rights. While specialized courts exist in a number of countries and may call on expert assistance, it may be more efficient to submit a dispute to an arbitral tribunal composed of at least one expert with specialized, relevant knowledge. In addition, the confidentiality of arbitration and other procedures offers advantages where know-how or other confidential information may be exposed in the course of a dispute. Established in recognition of the developments described above, the Wipo Arbitration and Mediation Center offers services in relation to 4 dispute settlement procedures. Mediation, a procedure in which a neutral intermediary, the mediator, at the request of the parties to a dispute and without the power to impose a settlement, endeavors to aid the parties in reaching a mutually satisfactory settlement on the basis of their respective interests. Arbitration, a procedure involving the submission of a dispute, pursuant to an agreement of the parties, to a mutually acceptable arbitrator or a tribunal of arbitrators, in accordance with the law and procedure adopted by the parties, resulting in a binding award. Expedited arbitration, an arbitration procedure where the rules limit the procedural choices of the arbitrator and the parties, in order to obtain a quicker result at a lower cost. This procedure may be practical, particularly for small-scale disputes which do not justify, in terms of personnel or financial costs, resort to court litigation or conventional arbitration. The above procedures may also be combined. Parties agree to try first to resolve the dispute through mediation. If this does not produce a settlement, either party may submit the dispute to arbitration or expedited arbitration for a binding decision. The services that Wipo provides in relation to the 4 procedures are essentially of 2 types. The first type involves making available to parties the instruments for the resolution of a dispute pursuant to one of the procedures administered by WIPO. 2. Such instruments are necessary, model contract clauses and submission agreements for initiating one of the 4 procedures, and rules for the conduct of each of these procedures, namely, the Wipo Arbitration Rules, the Wipo Expedited Arbitration Rules, the Wipo Mediation Rules, and the rules for the combined procedure. The second type of service provided derives from these rules. The rules envisage that certain functions will be performed by the International Bureau with respect to the conduct of the dispute settlement procedure, such as the following: assistance to the parties in selecting and appointing the mediators or arbitrators, if necessary with reference to the CENTES database of more than 1,000 arbitrators and mediators from more than 100 countries with experience in commercial, intellectual property and information and communications technology dispute resolution, guidance regarding the application of the relevant procedural rules, liaising between the parties and the tribunal or mediator with a view to ensuring optimal communications and procedural efficiency, assisting the parties in organizing any other support services that may be needed, such as translation, interpretation or secretarial services, fixing the fees of the arbitrators and mediators, in consultation with them and with the parties, administering the financial aspects of the proceedings, by obtaining a deposit from each party of the estimated costs and paying out of the deposit the fees of the arbitrators and mediators and any other support service or facilities, such as fees for interpreters, where they are required, when the proceedings take place at Wipo in Geneva, providing a meeting room and party retiring rooms free of charge, when the proceedings take place outside Geneva, assisting the parties in organizing appropriate meeting rooms and other required facilities, providing such other services or functions as may be required to ensure that the arbitration or mediation procedures are conducted efficiently and expeditiously. The services described above may be used anywhere in the world. While the Wipo rules are especially suitable in an intellectual property context, such as for a licensing dispute, they lend themselves to the resolution of all types of commercial disputes. The procedures may be applied in any legal system in the world, in any language and under any law chosen by the parties. In addition to offering arbitration and mediation services, the Wipo Arbitration and Mediation Center organizes conferences on arbitration and mediation, as well as workshops for arbitrators and mediators, covers both the CENT-S services and the remuneration of the panel. Under the Wipo schedule, the actual level of the fee depends on the number of domain names concerned, and on whether the case is to be decided by a single or three-member panel. Registries of new GTLDs, Aero, .biz, Coop, Info, Museum, Name and .pro, have, for the most part implemented, in addition to the VDRP, dispute resolution procedures. Specifically geared to conflicts arising during the initial registration phase, the purpose of these procedures is to provide trademark owners with additional means to ensure the protection of their rights on the introduction of these new domains. The Info Sunrise Registration Challenge Policy and the .biz Startup Opposition Policy are examples of such procedures. Furthermore, registries that are restricted to certain purposes, for example, .biz for commercial purposes, provide special proceedings to resolve disputes concerning compliance with their respective registration conditions. 4.6 Summary. WIPO's Development Cooperation Programs aims to raise the levels of socio-economic development in developing and least developed countries through their IP systems so that they can build effective partnership with developed countries. Towards this end, Wipo offers assistance in developing legal and administrative framework and structures for IP protection, training of IP personnel, responding to emerging issues and challenges before LP, increasing their access to IP information through the WIPONET, increasing use of IT in the practice of IP activities, and creating structures to support innovation and technology transfer, giving legal advice and assistance. The Wipo Worldwide Academy at Geneva is devoted to human resource development in the field of IP, providing teaching, training and research services. Repression of piracy and counterfeiting of IP is a crucial task of Wipo. It goes about this task in three ways: through administering many international conventions and treaties on LP, developing new legislative provisions, transferring the know-how to administer the international conventions. There is an advisory committee on enforcement of industrial property rights. The Wipo Arbitration and Mediation Center offers services to resolve IP disputes between private parties. It also serves to resolve internet domain name disputes. Thank you for watching. We will see you in the next video with the next chapter.